Welcome to the Five Stone Buildings webinar programme. We've just opened the live link, so we're just going to wait for a few minutes to allow everybody to join us before we start. Welcome to those of you that have joined. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to the Five Stone Buildings webinar programme. We've just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting for everybody to join, I shall just remind you of the house rules. So just to remind you that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom of our screen, and our speaker will come to them at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And just to remind you that we now have a separate section on the Five Stone Buildings website where you can watch a recording of this webinar and any slides used and any previous webinars that have taken place. We've now moved to a monthly webinar program. So instead of the previous weekly webinars, we will be doing webinars once a month with a view to hopefully doing some in-person seminars later on this year. But I will now hand over to Alex.
Thanks, Jo. Hello, everybody. As you can see, I'm going to talk about funeral disputes and dead bodies, and I see lots of people have come to listen, which is a great honour. I hope that this rather sort of attenuated rattle through the relevant issues lives up to expectations. I think that this is a fun topic. I think I'd be interested to know how many of you have had clients come to see you and say, we have a problem because, you know, my sister is trying to cremate dad and actually he always wanted to be buried or repatriated to Israel or the US or wherever it is. And what can we do about it? And by the way, it's happening tomorrow, and can you stop it? Or conversely, people come into your office and say, someone's just obtained an injunction that prevents me from conducting tomorrow's funeral. Can you help? But I think I've been approached in 4 or 5. I think I've done 2 that went to court properly, maybe 3. And it's difficult to know how common they are, but I think they're really fun because it's quite emotive for the client. That's fine. We are respectful of that. But it's quite interesting, I think, for lawyers because it's not really about the money for the client. I know they often say it's not about the money, but it really isn't about the money because it will cost them money. They probably won't get any money back. They might get their costs if they follow the event. The law is quite interesting. There might be an urgent injunction hearing, which I always think is quite interesting. And because the thing that the client is seeking isn't financially valuable, there is sort of relatively limited risk for the professional advisors, which is quite good because some of the decisions you have to advise the client on would, if there were significant financial risk, be quite high stakes because one never wants to obtain an interim injunction and find that it's been set aside and actually the client is now liable to compensate for this huge transaction that can't take place. But where it was only a funeral, the downside is limited. The first question to sort of think about in this talk, and I'm going to sort of look at how the court determines these disputes, how they come to court, and what one might think about if someone turns up with a problem. The first question that is interesting is can someone own a dead body? Because you always, clients tend to assume perhaps that their late parent or grandparent or even spouse, their body is now a thing, and by and large our law provides for the ownership of things. But dead bodies are different, and probably with good reason, given the particular nature of them and the place they occupy culturally. And the law is essentially that there's a duty on various people to dispose properly of a body. In the first instance, the deceased's personal representatives, in certain circumstances, local authorities, in other circumstances, perhaps people who are responsible for property where the body is. And those people have a primary right to possession and control of the body for that purpose. And the primary duty is on the deceased's personal representatives where known, but as we'll see, that only goes so far. But what it means is that in general terms, a dead body isn't property, and you can't sue someone to get it back in the same way that you would usually be able to, and you can't sue them for conversion or whatever it is that the personal property lawyers would tell us was the cause of action. And there's the case, one of the earliest cases called Williams and Williams, and it stands as authority for this proposition, although it's a complicated case because it's all about whether or not someone could be cremated, and the deceased had given, I think his executor in that case, sort of directions to obtain his cremation, for which purpose she had to lie to the Home Secretary and dig him up and put him in an Italian vase and ship him somewhere. And it's quite curious, but it was complicated by the fact that cremation was at that time not a lawful way of disposing of a dead body, and the Home Secretary certainly wasn't going to give a license to dig someone up who'd been properly buried. The facts of the cases are always quite interesting, I think, both the decided ones and the current ones. So the executor or administrator, if they've already been appointed, has a primary right to dispose of the deceased's body where that's possible. But where a dispute arises about how that should take place, and often, for example, in the same way that we see in probate disputes or other disputes, someone appoints their second partner as executor, and they want to dispose of the body in a particular way, but the children from the first marriage say no, he wanted to be buried in the same burial plot as our mum that he purchased 25 years ago, and the new wife is saying no, I'm going to have him repatriated to be buried in the garden of our house in France. And the fact that he appointed her executor, it gives her a sort of starting point to make a fuss and to say, look, I'm in charge unless something else happens. But as soon as there is actually a dispute, it's not going to count for much. I think practically it counts for a little more, because if the personal representative moves quite quickly to obtain what they want, then the fact that they are executor or administrator, and particularly if they have a grant or they're named in the will often persuade people like funeral homes to release the body to them, which is quite helpful. But where there is a dispute, the court will determine it, and there's a recentish case, Oldham Metropolitan Borough Council and Macon, which was in the headlines a bit at that time, which concerned the body of Ian Brady, the murderer, and he had appointed as his personal representative a solicitor called Mr. Macon, who I don't know, he didn't sort of present himself very well in that case. I think he was probably trying to do what he thought was right, which was to carry out his client's instructions, but he I think was also, it might be said, he was quite interested in the publicity, or he did nothing to discourage the publicity that sort of came to him, and that necessarily didn't do him any favours. But there, Ian Brady had left quite unpleasant instructions for how he was to be cremated in a ceremony at which a particularly distasteful piece of music about, I think it might have been, I always forget what it is, I think it's by Berlioz, and I think it's called The Descent into Hell. It's part of the Symphonie Fantastique, and that was thought to be incredibly offensive, as was any suggestion that his body might be scattered in either of the cities with which he had previously had a connection, or indeed where he committed his murders. And so two local authorities took steps to prevent that, and despite the fact that there was an executor who had a grant, who had control of the body, who wanted to make the decisions in accordance with what he said were the deceased's instructions, the court wasn't interested in that at all. And we'll come back to that case, I think. But looking at how the court might actually determine these things if you bring it before a judge, there are two jurisdictions that give the court power to make orders about the disposal of the deceased's body. And for many years, because courts took a relatively old-fashioned and incremental approach to the kinds of orders that they could make, they sort of proceeded on the basis that the disposal of the deceased body was part of the incidence of being a personal representative, being executor or administrator. And although it didn't give that person ownership of the body in the same way that it gave them quasi-ownership of the estate, it did give them the right to it. And so the courts began to use Section 116 of the Senior Courts Act, which gives courts a power to appoint someone other than the person who would otherwise be the personal representative. So either the executor or the person presumptively entitled as administrator, if there's an intestacy, for a limited purpose. And so what they would do is to appoint someone simply for the purposes of arranging the disposal of the deceased's body. And the statutory test were that special circumstances made it necessary or expedient to do so. And it's a section by no means limited to that purpose. And as I'm sure many of you have often seen, you often get Section 116 orders made where you just need to pass over all the people who would otherwise be entitled in an administration, or you need to appoint someone for a limited purpose simply to sell a property or something like that, where a limited grant of another kind isn't appropriate. But again, that's what in the end was done in Oldham Metropolitan Borough Council and Macon, the Ian Brady case. The other way in which the court can proceed is under the inherent jurisdiction of the High Court as exercised in the family division traditionally. And I think what happened is one of these cases came before a family division High Court judge. It might have been in Hartshorn and Gardner a few years ago, it might have been earlier on. And none of the cases in which Section 116 orders had been made in the Chancery Division were cited, and the judge decided that they must have a jurisdiction to determine these kind of disputes, and said, well, that's just going to be part of the inherent jurisdiction of the High Court to determine disputes about dead bodies. And so they did that, and they made an order. And so now there are two jurisdictions, and given that sometimes these cases come on in the family division and sometimes they come on in the Chancery Division, and moreover, many of the judges in the Chancery Division are not immediately familiar with grants of letters of administration and Section 116. I find the tendency, unless you actually need a grant for some reason, it has probably been towards just making orders under the inherent jurisdiction. And I tend to say, well, you know, I want an order that deals with this dead body. There are two jurisdictions, and frankly, you can make an order under both, setting out who's to have power to dispose of it, and where necessary, how it should be disposed of. But as I say at the bottom of the slide there, in cases where you might for some reason want to show something approaching title to a dead body by the time you've been to court, you might want at the bottom of that order, and a grant shall issue to this person under Section 116 for the purpose of carrying out the directions set out in this order. But usually a court order is good enough for most funeral directors and coroners and people. So that's the slide we want. In terms of the kinds of orders that you might get, there was previously a view, probably largely in connection with the way in which orders used to be made under Section 116, that said that the court had a power to direct who should dispose of the body rather than how it should be disposed of. That therefore, usually, you'd get people coming to court saying, well, I want to do it this way, and she wants to do it that way, and you should pick me. And that, I think, is no longer the case, if it ever was. And the best authority for that is, again, the Ian Brady case, where not only did the court decide how and who was going to dispose of the dead body, but the way in which the court gave directions for its disposal were incredibly detailed, much more detailed than it would be in most cases. So there were specific directions that the funeral should take place at a particular place, at a particular time, out of hours, that no one else should be present other than the necessary staff to operate the crematorium, the personal representative and a representative of the local authority, that no music or flowers should be provided, and that the body should be cremated and the remains disposed of at sea. The court further provided that the parties could come back and argue about that further if any of it gave rise to problems in practice. But I think in most cases, the dispute that one ends up asking the court to determine is about whether it's my way or their way. Is it sister's way or brother's way or mother's way or son's way or whatever. But I think it can help in brokering a deal, and courts can sometimes see a way through to say, well, actually it's going to be this middle way, and regardless of which of you is in charge, here is how it's going to be. Yes, you want a funeral here, but here is a direction that everyone is permitted to attend. But I think unless the circumstances are truly exceptional, a court is really going to try very hard not to decide things as detailed as what the hymns are going to be. But it would, I think, be possible. And of course, it's a jurisdiction in which clients really sort of think it's a matter of principle. So sometimes they can want to go all the way. Whether you'll win or not, when the client turns up and says, this is what I think should happen and it doesn't appear to be happening, can you help? I think there are two questions. Firstly, if the thing is happening very soon, will you get an interim injunction to prevent whatever it's said is about to happen? And secondly, having got it, will you successfully get an order that it happens your way when the dispute comes back on the return date? It's probably best to take them in reverse order. On the substance, when determining a dispute under the inherent jurisdiction, the following list of factors, which are frankly exactly what everyone would think were the most reasonable factors, are probably going to be where the argument lies. And they're what you might think they would be: the deceased's wishes, reasonable requirements and wishes of the family, the location with which the deceased was most closely connected, and really importantly, and sometimes this last one can provide a bit of extra leverage in the right case, that the body be disposed of with all proper respect and decency, and if possible without further delay. So if it's the case that what the other side want is going to take a long time, it can give you just a little bit more ammunition if you can say, look, this isn't going on long enough. Yes, you can come, yes, we can do it in a way that can be agreed on, but actually it has to happen, for example, in this country, because the deceased has already been in a morgue so long, and that's completely inappropriate. And further factors, or rather more information on them. The deceased's wishes are not necessarily binding. See the case in which they wanted to be cremated and weren't, but they are highly relevant. And I think that cremation case has to be viewed against the lens of its time. Cremation is now regarded as a particularly reasonable thing to do with your body, whereas then it certainly wasn't. Anstey and Mundell, it's a case I was in, they were a particularly weighty factor in that case, that the judge concluded against my client's entreaties that the deceased had wanted to return to Jamaica for burial, his body returned to Jamaica for burial. And so that's what happened. The detail that always lingers in my mind about that case is that the litigation lingered on so long that an open casket funeral was no longer possible. You probably won't thank me for that. And then there's this case at the bottom, which I avoid pronouncing without having practiced all morning. And in those particular circumstances, the deceased's wishes were the surest and strongest guide as to the approach that the court should take. Because we're dealing with something so essential, sometimes issues of human rights are said to be relevant. There are sort of two approaches, and depending on the argument you're making, it rather depends on which one you want to play up. But there's a case, the first case, quite a sad case, called Burroughs and Her Majesty's Coroner for Preston. And what happened in that one is that I don't want to get the facts wrong. The deceased was a young man who had been an Indigenous Australian, was an Indigenous Australian, but had his whole life, I think, been treated as the child of a English couple in England. And latterly, he'd re-established a connection with his birth mother, if not his birth father, who I think had already died. And then he was tragically killed in a road accident, really quite young. And there was an extensive and quite sad dispute about whether his remains should be returned to Australia for burial in compliance, or for disposal in compliance with the tradition there, or the Indigenous tradition there, or whether or not something more, well, something different should take place in the UK. And there was a sort of middle ground about whether appropriate Australian rituals could take place in the UK. And in those circumstances, human rights were said to be something relevant. You can see how, given the sort of historic factors at play there, the court was sort of might have felt it was quite relevant to consider that angle, and it was probably something all the lawyers were attuned to. By contrast, that's certainly not always the case. Although the deceased's wishes are always going to be relevant, or potentially relevant, in Ibuna and Arroyo, which involved the return or non-return to the Philippines, I think, of a Philippine senator, and I think the dispute was between either his wife and his ex-wife, or perhaps two women purporting to be his wife, one of whom had some power of attorney and the other one was married to him at death, possibly. Peter Smith, with characteristic bluntness, or directness at least, said that he didn't really see any application for human rights principles in the context in which the person with the said human rights was dead. I don't know whether that's right, and it may be that there's sort of European jurisprudence that would tell us whether human rights are capable of having a bearing where they belong to someone who is dead. One would have thought that insofar as the family's wishes were going to be accorded rights in a human rights sort of area, that they weren't going to be impaired by the fact that the person whose body we were talking about was dead. So I would doubt if human rights considerations are completely out, but equally, are they really going to take you much further than the deceased's wishes? I think it's probably not the case that anyone's going to say human rights mean that the deceased's wishes are determinative in a way that English law has traditionally not been very interested in. Both cases were considered, as I say, in Re JS, which is an extraordinary case I'll mention later. And it was said that the deceased wishes were relevant, perhaps highly so, but not determinative, and I think that's probably right. So in terms of where this might be going in your instant litigation, I think what I often find is that the people turn up, they say, this is all very bad, I want to stop it. You say, well, that will cost you some money and you may not get it back. There will be a risk as to costs. If you're lucky, you'll win and costs will follow the event, but I can't promise, because courts are quite sympathetic to people with genuinely held beliefs about how their father or spouse or whatever should be buried. But sometimes they go ahead and your client incurs the cost, or one's own client incurs the cost of going to court, or perhaps one incurs the cost of considering it after an injunction has been served on a client. But people don't often want to gamble the costs of the return date, because then by the time you're into a full-on substantive dispute, you're going to have, unless the facts are incredibly straightforward, at least a day-long hearing and possibly longer. And you can imagine that the evidence on these things can be almost as extensive as the evidence you might want in a probate claim. But usually the hearings are shorter because the court wants to accommodate them quickly, because the court takes the view that the deceased's body should be dealt with quite quickly, and things shouldn't linger on as long as your average probate claim, which I think is absolutely right. but it's still going to be a substantive hearing. And I think by the time you get to a return date hearing, both parties really are at risk as to costs, even if they weren't already on a sort of win or lose. You might get one of those orders where the deceased has told people different things. You might get one of those orders that costs come out of the estate, but I certainly haven't been successful in that. You're not, I think, going to get an order that costs come out of the estate simply on the basis that you represent a personal representative. Because I think once a dispute arises, the role as the personal representative really falls away, and they're just a family member having an argument about it. And I certainly wouldn't advise any professional personal representative to get involved, other than filing an acknowledgement of service if necessary to say we'll abide by the court's order or the parties' agreement. I suppose it's just possible that where a professional for some reason had control of the body, either because they were paying the funeral director's fees, or perhaps because they weren't a personal representative, but they were a funeral director or a hospital, or someone like that, they might apply to court. And if you did that because you simply couldn't get an answer that out of the family who agreed, and you said, look, I'm going to have to apply to court because I don't know what to do, then I think you would hopefully get your costs from somewhere. But if there was no estate, that might not help you very much. There's a case called Hamouth in which Lewisham Hospital had to apply to court because the families couldn't agree. I think they probably got their costs. And sometimes coroners do. But the point is, I think that after some initial flurry of activity and maybe a hearing, the parties often broker a deal. And I think that does, it's made easier by the fact that the court's jurisdiction technically can descend into such minutiae as exactly how the funeral should be conducted, because you can say to the other side, look, okay, well, we're not going to agree to your repatriation of mum or dad to some second country, but we will make the following compromises and vice versa. And then you can embody that in a consent order or in a Tomlin order, and that can give everyone a reasonable degree of assurance that what has been agreed is going to happen, and then often there can be some deal on the costs as well. And there has been, I mean, it's not uncommon for people to end up agreeing these things, and obviously that's the best outcome. I think in practice, if one's client turns up and says, what can I do? This is all outrageous. I think it's quite important, unless the circumstances are sort of exceptional, that you only try and get an injunction or a court order against the other family members or friends or whatever who are trying to take active steps. I think what you do not want to do is attempt to get an order against a funeral director or a hospital or a coroner, because although you might get one, you will almost certainly end up paying their costs of having it discharged. And they, by and large, will only act on the instructions or requests, depending on who they are, of the other people. So I think what you want to be doing is saying, you know, you write to the third party who's holding the body and you say, do not release this body to them. Please agree that you won't do that. Maybe you get a response, maybe you don't. Then you respond to then you write to the other party who's trying to do something you don't like and say, will you agree not to get the body and do anything with it without 48 hours notice to us or something? Please, can we work out our differences? Here's what we think. And then they don't respond, or they say no, because that's what people always do, because they don't really believe anyone's going to go to court over this. But then your client says, no, I really mean it. Then you can write them again and say, give us this agreement, otherwise we are going to get an injunction. And then preferably issue your claim and draft your evidence and so on and serve it on them and say, agree now, otherwise we will be in court tomorrow. And if, as my experience happens, it seems quite often, they just don't respond because, I don't know, possibly people who have managed to get themselves into such dispute with members of their family about even how a dead body is going to be disposed of, are not thinking that straight and may not be the most reasonable people in the world. And so they just don't really get into it, or they send you back an aggressive letter saying this is absolutely ridiculous. I'm Dad's executor, I'm Dad's eldest son, I'm Dad's second wife, of course I can do what I want. Then by that time, I think you know, assuming that you really do have everything you need to get your injunction, and I'll come to that in a second, that there's really no reason not to seek one, because you've done all the things that a party needs to do before seeking an injunction. And that reminds me, I think I must have messed up my slide. No, I meant to come back to it, because we looked just for a moment ago at these factors that the court's going to consider on the substance. You know, are we going to win? Well, the biggest question on an injunction is, are we going to win, you know, to a sufficient standard at which a court will, in the interim, hold the ring? And that test is not a particularly difficult test. It's the American cyanamide test. Do you have, is there a serious question to be tried, which has been put as whether or not your cause of action is fanciful or reasonable, fanciful, or there's another word I've forgotten. I'm sure many of you can remember. But it's not very difficult to get over. If your client isn't completely impossible, and they haven't just made up what they say about these factors here, then almost certainly there is going to be a serious question to be tried. And then the other two factors that the court will consider on an injunction are, well, where does the balance of convenience lie? And whether damages are an adequate remedy. And the balance of convenience between cremating and not cremating someone tomorrow, because it's only the balance of convenience on whether you should get the injunction and it should be paused until the dispute is worked out, is always going to fall on the side of granting the injunction. Because once you've cremated someone or buried them or repatriated them to another country, you're not going to get them back, even if it turns out that what your client wanted was right all along. And then the final factor is the court's going to consider is whether damages are an adequate remedy. And damages are never going to be an adequate remedy, because it's not about the money. You know, if it mattered that much to the clients that their loved one was disposed of, it's not the best combination of words, in a particular way, then clearly it's not going to be made up to them by money. And actually there isn't a jurisdiction to give them any damages for what has happened. It's less than psychological damage. There's no sort of duty not to cause them that anyway. So they're not going to get any damages, and therefore damages aren't an adequate remedy. And so 9 times out of 10, if your client's case is quite reasonable, then the court will probably give you your injunction, and then you'll get to this stage and you'll end up brokering some sort of deal. Or, as I say, you know, if there is no deal to be done, you can go forward to a substantive hearing, but the costs increase, the risk increases, and the test is more difficult to get over than the injunction test. In terms of injunctions themselves, as most of you will know, I'm sure, the thing that takes the time is drafting the evidence. In an ideal world, you'll have served the evidence on the other side and said, look, we really mean it, will you agree? And if you don't agree, we're going to court and you'll have to pay the costs. And that means that really you want to have drafted the evidence by sort of lunchtime, served it on them, and then made an application later in the day for a hearing the next morning, at which you can then say, look, we gave them notice days ago, they've refused to confirm what we wanted. We've drafted and served the evidence on them yesterday lunchtime, and they still haven't given us what we wanted. Now we're here and we'd like our injunction. And that's really the best pattern to fall into. In terms of sort of what isn't achievable in this jurisdiction and that pattern of sort of application and claim, it's really very broad. There are 2 cases that illustrate that. One of the cases I acted for an Islamic charity which had absolutely no connection whatsoever to the deceased. But the person who ran the charity was friends with sort of some of the members of the Muslim community in the town where she lived, and the people there didn't want to bring this application because of the costs risk. So the money could be raised amongst the community to pay lawyers' fees to bring the application, but no one wanted to be the claimant. And this charity was willing to be the claimant, which I thought was a bit brave, really, given that it wasn't really any of their objects to bring these sort of proceedings, and they were taking a risk, but they did nonetheless. And the judge had absolutely no problem with the fact that this sort of do-gooding body on behalf of the community was bringing this application. Obviously, the less it was a relatively good application, and the less good the application had been, the less well made out on the facts it would have been, the more criticism we might have suffered. But that was fine. And then the really far out case is REJS, disposal of body, which is a really sad case about quite a young girl, I think 12 or something, who was dying, and she knew she was dying, and so did both of her parents, who were estranged, I think. And she wanted to be cryogenically frozen so that there might be hope of her recovery or reanimation. And her mother was prepared to support her in that, and some quite shady American organization were willing to come and do the freezing, and the hospital was just about willing to put up with it at the moment of her death if the court said that that's what should happen. But her father said that this is just absolute nonsense. I'm not going to permit it. And so the mother made an application to court for an order before the young woman had died, that when she did die, her body was to be disposed of in this way, and that the mother was to have the right to take out a grant under Section 116 for the purpose of doing so. And the family division decided that those were orders that they could make before death using the inherent jurisdiction and the Section 116 jurisdiction. I don't think that the children jurisdiction as well, but possibly that one. But that's a strange and very sad case. Incidentally, the judge was not impressed by the cryogenic freezing people. He said he wrote a sort of coda to the judgment about how appallingly they'd performed when the moment came, and it was all very distressing for everyone, and the hospital thought it was terrible. Anyway, that's about it, really. How do I just stopped my screen sharing? That's what I wanted to do. That's about it. That's the jurisdiction in a nutshell. The cases are quite interesting. The facts are quite strange. People have to be really quite wound up to want to go that far. And that's probably all I have to say. I don't know whether there are any questions. I'm not sure there are, which is fine, really, unless Joe's going to tell me different.
No, that's fine. There's no questions. If anyone has any questions afterwards, please feel free to email us and we can pass them on to Alex for comment. And like I say, this recording will be available on our website. Thank you.
Thank you all very much, and speak to you again soon. Bye.